The panel on the last case, I'm going to introduce Judge Jay Cohen from the Ninth Circuit, who's going to be sitting with us on this one.
Actually, I'm here now. I'm not in the Ninth Circuit anymore.
Originally from.
Yeah, can you close this?
This is not the first time I've seen Judge Cohen.
Okay, Sabina Price-Jones versus Robert Price-Jones.
Good morning. May it please the court. My name is Bill Gressley. I'm representing Sabina Price-Jones, the appellant here. I have an aspirational goal of 5 minutes for rebuttal, and we'll see if that happens. It's a rarity. The first order of business is sort of an odd one, and I apologize. I'm having terrible allergy issues to all the pollen, so if you see a tear coming down my face, it's not because of anything that you asked me or anything that my friend Ms. Sussman said before I got up here. This is the first time. I've been doing this for a really long time. This is the first time I have ever represented an appellant, and the first thing I have to argue is that this is not a final order and it shouldn't be here. What
did your notice of appeal say? What did your notice of appeal say?
It probably says it's a final order, and that...
Indeed it does.
Yes, it does, and guess what? I was wrong. The real issue is there any prohibition against filing a notice of appeal that turns out to not be a final order? And the answer is no. I spend most of my life in between this court and the first doing this. I get regular order to show causes why this allegedly final order is really final and appealable. This is a jurisdictional issue that can be raised and has to be raised.
Why don't you explain why you think it's not a final judgment?
It is in form, not what we're used to seeing, but that's not important.
Yeah, that's right. That's not important.
No, I agree. But what does this order actually order the parties to do? It has 4 provisions. One is it dissolves the marriage. It's ordered in a judge that the marriage is dissolved. Dissolves an injunction that was previously entered against the former husband. Orders the former husband to pay a $19,000 some odd equalizing payment, and reserves jurisdiction to modify and enforce the final judgment.
No, it does a lot more than that.
Well, it makes a lot of findings, Judge, but it does not order the transfer of the properties.
It says that this judgment, will, operate to, transfer properties. If
but it doesn't order the LLCs that own the properties transferred.
It's just that's a very narrow interpretation of the language. It might not have been a model of clarity, but it's certainly in every piece of property, the husband is awarded exclusive use and control of the Bishop estates. You've got the Taurus Circle in Jacksonville, and I don't see what you're really talking about. Husband shall be awarded exclusive use and control of Tech Shark.
Those are all findings, and there's no question that they exist, and we've never argued to the contrary. What our argument is, and this was something that occurred because somebody for the first time took a look at this that had not been in the middle of what I call the weeds, all the minutia about the case, which is that it does not order anything except those 4 items that I pointed out to you. Yes, you're right. It says this document will act as a conveyance if the parties don't execute documents. But it does not adjudicate who gets what in a legal sense, and that's why we've said that this is not a final order.
Now, let's talk about the marital residence. Marital residence is owned by the parties, is tenants by the entireties. They've agreed the property shall be awarded to the wife. Wife is directed to attempt to refinance the home, get the mortgage solely in her name. You don't think that disposes of that piece of property?
No, sir, and that's our position, and if the court disagrees with that, that's why I've written a brief that has 25 other pages to it, because there are significant substantive issues as well.
Well, why doesn't that dispose of that? I mean,
because it doesn't order it done. It says that you shall do that. It doesn't order her to do that. It doesn't order the LLCs to be transferred to the individual parties that they were given to. And that's the essence of what finality is, and I've spent half my life tap dancing around. What is finality?
And did you raise that on your motion for rehearing?
No. No, it has not been raised until I raised it in this brief. And I've cited this.
So, but we've got a lot of case law that talks about, what you're saying is that the language isn't there in the final judgment. Of course,
The adjudication is not there.
Yeah, you don't know what the final judgment's going to look like until you get it. And so that's why, particularly in family law cases, we have a body of case law that says unless you bring this up in a motion for rehearing, you've waived it for appellate purposes.
Yes, except for a jurisdictional defect, and that's our position. And if the court determines that this is not that this is final enough, that somehow the trial counsel had to raise it in a motion for rehearing, then that's your prerogative. I'm obligated to raise what I see as valid legal arguments on behalf of my client, and our primary position here is that this is not a final judgment because it finds lots of things, many of them erroneous, but it doesn't order anything. So I'll leave this in 1 second. The case that I cited as supplemental authority, the Salente case, had a guidelines worksheet showing that the former wife was paying for the child's medical insurance, but it never ordered her to do so. And the court said, you can't legally enforce that unless you order her to do so, and that's the essence of our position. The real fundamental problems with this, if we just assume for purposes of this argument that this is a final and appealable order and that somehow, because it wasn't raised in rehearing, we don't get to talk about it, is the mistakes that were made and the misapplication of law and the equitable distribution. The alimony provision, there's many defects in that, but if you reverse on the equitable distribution, then alimony's got to be set aside as a matter of law because you can't determine alimony until the equitable distribution's finished. The first order of business on the equitable distribution is the Sheffield property.
Counsel, was there ever any signed agreement as to this property?
No, but here's how this came up and why I think that that's a red herring argument and a question that sort of begs the real question, which is all of the proposed equitable distribution sheets in this case from both sides had my client receiving this property.
Right, but that's a proposal to the court. They've chosen not to settle the case in mediation or any other way. They've chosen to let the court decide what to do. So you can propose all you want. I mean, they could propose that the wife gets the china and the husband gets the motorcycle. But if the trial judge wants to switch that, they can, correct?
If there's a basis to do so, and here's the problem with that.
It's equitable distribution.
If it's equitable.
Yeah, and I can tell you that those who know me know that I have a little bit of a twisted sense of humor. When I was on the trial court and handling divorce cases, I wouldn't hesitate to do what Judge Grosshands just suggested, which is to give the wife who doesn't fish the bass boat and give the husband who doesn't sew, the sewing machine, because it's equitable distribution. And that, if the numbers worked out right, that's what I would do. And so in this case, the trial judge had decided he wanted an equitable, as opposed to the unequitable distribution requested by the wife, and this made the numbers work out. What's wrong with that? Why is that reversible error?
I say it's reversible error because the other side took the position, and this was proposed by them in their proposed final judgment after the trial's over. And that's the problem, is my client would have been glad to testify as to why this particular property had meaning for her in a sense that you do that.
When you all don't decide, when the parties don't settle a case, they say to a judge, raise my kids, decide what school they go to, decide what their vacation schedule is going to be, what sports, the trial judge then raises the kids. And when they decide, when we can't settle this case, we can't settle anything in this case, we're leaving it up to you, Judge, this is how we think, this is our proposal, but, you decide, why is that reversible error?
What you're telling me is that if you have both parties agreeing on an equitable
No,
distribution.
you don't have both parties agreeing. You have no signed settlement agreement.
No, you have them agreeing in your proposed distribution. So you have to put on the testimony at that point so you have a record of it.
If you don't have a stipulation, yes, that's right.
Fair enough. Let me be glad that there are many more errors in this equitable distribution that don't rely solely on that one. I consider that to be a sharp practice, but I've now been educated, and I will make sure that my trial counsels know. I don't care what they propose. Put on the testimony that you want as to why you should get a particular piece of
If
property.
you don't have a signed agreement, if you don't have a settlement agreement, or you don't have a stipulation, you could go to the trial court and tell the trial court, Judge, we've resolved the following issues, and we stipulate to the final, to these issues. But the fact that you've done a pretrial,
Multiple
statement,
ones. That it was never a contest. So my
I mean,
client.
I understand what you're saying, and
I hear you. I mean, if that's the ruling, that's the ruling.
and I think that probably both sides were surprised by that ruling. The question, though, is it reversible error?
Well, the other side proposed that he get this property in their proposed final judgments, and that was raised on the motion for rehearing. That was the first time we'd ever seen that there was going to be a claim that that property should go to him. So that was the basis for my claim, that this was not equitable or fair. It was actually a sharp practice, and I believe that, but I understand your rationale.
I'm not unsympathetic to your argument. I'm just trying
I just want to know what the law is, Judge, and you've told me that it doesn't
I haven't
matter.
told you anything yet.
Well, you gave the bass boat to the wife, so I understand the concept.
What I'm trying to do is to go through the analytical process of how this constitutes reversible error when you don't have a property settlement agreement and you don't have a stipulation. What you have are proposals.
Yes.
How is that reversible error?
Because no one on my side of the case had any notice that they had to put on the evidence as to why this was a piece of property that had particular meaning and value to my client, which is part of the analysis that you're supposed to do with equitable distribution. It was never raised until the proposed final judgment, and following your statements to their logical conclusion, you have to be prepared to put on all of this at trial absent a signed stipulation or an oral one on the record, and I hear you. The Taurus Circle property, the statement in the answer brief that the husband testified that it was generating $800 a month is inaccurate. I pulled the volume out. What he said is, I'd put $800 on my cash flow worksheet, but I don't know if it's rented or what it's rented for because my client got the rents. There was never any testimony that this property was rented for $800 a month. And in fact, the only time that came up was when Applebee's trial counsel asked the expert CPA, the real estate valuator, were you aware, did you account for the $800 a month in rental income that's being generated? And the answer, no. And the reason is because there wasn't any $800. And the judge used this to go from a $32,000 valuation to $74,000. And it's not a fact.
Which property is this you're talking about?
This is I think it's Taurus Circle.
Yeah, I think that was $70,000 instead of $37,000.
Yes, it was, I think, I wrote 74 and 32 was the disparity, but it's close enough for what we're doing. The distribution of the airplane is relevant primarily because the judge awards this to the husband. He spends, this is his hobby, he spends somewhere between $1,800 and $2,000.
Let's go to let's stay on the Taurus property for just a little bit. Yeah, you've got the testimony of the real estate broker, and then you've got the testimony of the husband, correct?
Yeah, the husband doesn't know that it's rented and doesn't know how much rent if it is.
In terms of value.
I'm sorry?
The value.
The value, yes.
Yeah, the value, his testimony
that he got from Zillow.
was $70,000. And an owner typically is competent to testify as to the value.
Absolutely, but they got to have a basis for it. And his basis was, well, I looked it up on Zillow. Is that a basis? If the court says that's legally sufficient, then okay, the judge could have decided that even though we have real numbers and this property's never been rented, we can go with one that's double in value from what our expert testified. I'm not asking this court to judge whose witnesses are more credible. I submit that a owner who has no basis of knowledge, personal knowledge, because it's his property. The testimony was that my client was the one who managed all these properties. He signed the tax returns every year. I'm about to eat into everything I've got left, and so I want to make sure that before I get rebuttal time that I've at least mentioned a couple of things.
Already rebuttal time.
I'm painfully aware, Judge. Thank you. Excuse me. The valuation of the accounts. I understand trial judges have discretion as to evaluation, but it has to be something that has a basis in fairness, equity, or some legal basis. The Exhibit A, that is the equitable distribution, picks for the LPS stock plan and the 401k Wells Fargo plan of the husbands, picks a date that has no meaning whatsoever. January 17th, 2016. Well, this was a 2015 filing. The trial was held in 2017. What did it do? Well, it found that the first account that was valued for purposes of distribution at 128 and some change was 149 at the date of filing, and then the Scottrade account had 140 at the date of filing, but was now valued at 69. And the judge said, well, he used it for attorney's fees and for whatever else he wanted to use it for, and therefore I'm only going to use the lower amount that I've picked a date that has no bearing, no relation to anything of illegal significance. The judge said he was going to equally distribute the parties' assets. Page 14, paragraph 41 of the amended final judgment discusses a loan from my client's brother. His name is Peter Wu. The court found that there was a $15,000 to the wife from Peter Wu. However, the loan is alleged to have occurred after the filing of the petition to pay for attorney's fees. Therefore, the loan is non-marital. Well, okay, she borrows money to pay for her attorney's fees, and the judge says, no, we're not considering that. The husband uses his retirement accounts that are marital assets to pay for attorney's fees, and the judge said, no, that's okay. My client gets to help subsidize your attorney's fees. And the court reserved jurisdiction to determine attorney's fees. So the valuation of that property, of those accounts, doesn't meet the threshold test of some date that's fair and equitable. What it looks like is that the former husband proposed by picking random dates when the accounts were at their lowest value, and my client used the date of filing. The other two issues that I have to raise so I can address them again is the alleged loan to the former mother-in-law. The existence of this alleged loan showed up the last day of trial. Documents were presented that were not allowed into evidence, and if you look at, the judge found it was a $184,000 loan. Volume 1, page 185 of the transcript is where the former husband is talking about it. My client's testimony was, yeah, we had a loan with the grandmother, but never a loan with the mother. But the important part of this is the former husband testified that they had paid, there were two separate loans. $20,414 was the balance on the first loan, and $41,961 was the balance on the second loan. That totals $62,375. And what the final judgment does, the amended final judgment does, is makes a marital debt of $184,000, which was the original loan amount, without any credit for the payments that were made. And finally, the alleged loan from my client's father into one of the Southland LLC. The LLC, original LLC documents showed that he was a 64% owner, and all of the tax returns every year that the appellee signed showed that he was an owner of this LLC, and instead the judge said, no, it's just a simple loan, and there's no factual basis to do so.
Was he on any of the title for any of the properties?
The LLC would have owned the property, and it's unclear whether that owned property or whether it was receiving income from other properties. That was an intricacy of dealing with LLCs that never even came up as a discussion. The question was, did he invest in the LLC, or did you just loan the kid some money? And there's no basis for the finding, no legally sufficient basis for the finding. It was just a loan. My best nightmare, I have 25 seconds left for rebuttal. Thank you.
Goes fast, doesn't it?
May it please the court. I'm Stephanie Sussman on behalf of the appellee Robert PRYCE-JONES. To start with the first issue raised in the appeal that Judge Cohen asked some good questions about, it's this issue of finality versus the format of the judgment. I think to start with, it's clearly a matter that was not preserved for appellate review. The motion for rehearings in this case from both sides were extensive, and the trial judge actually held a rehearing and amended the final judgment, which indicates to me that had this issue been raised with complaints about the way this judgment was formatted, the trial judge was open-minded, open-eared, and probably would have fixed whatever purported deficiencies there were in the formatting. And you can see where he pretty much fixed all those types of errors that either party raised.
Well, are there deficiencies in the formatting?
I don't believe so, Your Honor.
Because, I mean, if you look at some of the distribution, for example, the timeshare with Hilton Grand Vacation Club, the property shall be awarded to the wife. That's finality, right?
I believe
The
so.
airplane shall be awarded to the husband.
Yes, sir.
But then a bunch of these don't say that. They say the parties have agreed that the property shall be distributed to the wife. There's a big difference, isn't there?
There is language.
What they agreed to, right?
I think there's a difference in those two statements, but I think as trial lawyers, which I think all of us have been, and we see different final judgments from different judges, and you can, in some cases, tell which judge wrote which judgment before you get to the end. But I think the important point is, does this judgment clearly direct the parties what they are supposed to do and what they are going to be held accountable for?
Okay, so if you look at Holler Air Park, the parties have agreed that the property shall be distributed to the husband.
Yes, sir.
Does that distribute it to the husband just because they've agreed?
I don't know that that specific statement does,
Some
but
of them are worded that way.
okay, but I think if you look at the judgment as a whole, it incorporates specifically Exhibit A and Exhibit B. And those exhibits outline the details of the equitable distribution as to all the real estate, all the accounts, all the personal property. And it says, that this is the equitable distribution. And so when it does that and then outlines the things that either the court's ordered or that the parties have agreed to, and then awards the equalizing payment, I don't think there's any question when you read it all together that that's what the judge did, it is an effective final judgment. And in my experience on this issue, and a lot of times it comes up in contempt proceedings when the question is, did the parties know what they were supposed to do? Did they know what they were going to be held to? I don't think anyone can read this judgment and reasonably say there's a question of what was awarded, what they're supposed to do, what their
It's
obligation.
the Chevy truck.
If you can let me pull the amended final judgment.
Paragraph 29, the court finds the wife presented evidence regarding the value of the truck. Its value is $25,000.
On Exhibit A of the equitable distribution worksheet, the 2014 Chevy truck is awarded to the wife at the
You have to
value.
go back to the exhibits.
Well, yes, you would have to look at the exhibit to answer that question. But I think when an equitable distribution exhibit is incorporated into a judgment and then the parties are directed to pay an equalizing payment based on that distribution, I think it's an effective distribution of the assets and liabilities that are in the marital estate, especially when the courts recognize the evidence presented by both parties and then puts together this spreadsheet of what the court was going to do.
Let's talk a little bit about the Sheffield property. I'm not unsympathetic to their argument. I wouldn't necessarily use the word sharp practice, but it seems that there is almost a due process issue where you don't seem to contest an issue in the pretrial statement, and then you present a final judgment that flips the landscape.
And I do understand that sentiment. What I would say is the proposed final judgments are not actually part of the record. So to the extent, I actually have not seen either one of them. Neither one of us were trial counsel. So I look back to the motion to rehearing to see what they actually raised as to their complaint about Sheffield. And the matter raised in the motion for rehearing was not that they were surprised by the fact that the former husband may have, in his proposed final judgment, put it in the former wife's column, or that the judge awarded it to the former husband over this purported stipulation. That argument's not contained anywhere in the motion for rehearing. So if you look at what they presented to the judge on rehearing as to that property, it was only they're saying the former wife wanted this and she should have had it. But there was no mention of, well, this isn't fair, this isn't right, or it was trial by ambush. So I'm not saying the former husband did not put it in the proposed final judgment. I'm just saying it's not something, and I'm sure Mr. Gressley is being forthcoming about that.
Well, if it's not in the record, it's not in the record. We don't consider what isn't
Yes,
in
sir.
the record on
But-
appeal.
But I think as to that point, look, nobody wants to be ambushed at trial or surprised at trial, and especially not after a trial and a proposed final judgment. But again, if you look back to the motion for rehearing, that wasn't the complaint they raised to Judge Beck to give him a chance to correct it if he thought that that was inappropriate. And I think the point that was covered clearly earlier is that there was no stipulation. There was no agreement. If you look at the former husband's testimony, he says,
What's the purpose of the pretrial statement? Isn't it to narrow the issues?
yes, sir, I would agree with that.
And if the pretrial statement has the Sheffield property and both sides say the Sheffield property ought to go to it doesn't matter who, to the wife, why doesn't that settle that issue and take it off the table for the course of the trial?
Well, I think,
I understand it's not a stipulation.
yes, sir.
And that it's not a signed settlement agreement, but I'm talking about it just in terms of the conduct of a trial.
And I think it does direct both parties' conduct of the trial, and especially in family law cases when we could be talking about million-dollar businesses and then also sewing machines. So you have to be able to narrow what you do. So I don't disagree with that sentiment. But what I will say, to bring in one of the other properties that was raised by the appellant, is on the initial proposed equitable distributions on the Taurus Road property, both parties used that $70,000 value. And it wasn't until trial, after the first trial was continued, and then the appellant hired an expert that wasn't disclosed until between the two trial dates, and then had that person testify at trial over the former husband's objection, that all of a sudden she said, oh, well, that $70,000 on my proposed equitable distribution is really $37,000. And so I think if you look at this case specifically,
So your argument is what's good for the goose is good for the gander? Is that your argument?
that's not my argument, no, sir, but I'm just raising it to point out that if you're looking at it from an equity standpoint, that we prepare for trials and we do the best we can, and we put things in proposals that we think are going to play out, and that's not always the case. And in this case specifically,
But if you're the lawyer representing a party, and you've got a pretrial statement, and both pretrial statements say this property should go to this person, you're not going to bring witnesses in. You're not going to put on evidence. You have a limited amount of time that the trial courts give you to present your case, and so you're going to narrow the issues and address what you've got to address, and so you're not going to present any evidence on an issue that seems to be settled and agreed upon by the parties, are you?
not necessarily, but what I will say is that generally, if there are things that people really believe are agreements or stipulations, the first thing we do at trial is tell the judge, either in writing or on the record, prior to coming to court today, we've all agreed on these issues. And that way, there is no question after a 5-day trial or a 4-day trial of whether this was really an agreement or not. And that didn't happen here. And I think in the family courts, that Mr. Gressley and I practice in this circuit, in the Fourth Circuit, that's what we're asked to do, and that's what we generally do, and that wasn't done here. So I don't disagree with what you're saying, Your Honor, but what I will say is I think neither party did that. The former wife didn't even question the former husband on cross to say, do you agree that like, this house goes to her. That was not in the testimony. And I think what happened here, if you look at the whole transcript and what the trial judge did, he decided that the former wife needed to get the properties that were most likely to produce rental income. And he also didn't agree with her that the distribution should be unequal. And so he took those proposals, and after making comments about those things at trial, put it together the way he thought it was most equitable to accomplish the court's goals of an equitable distribution, while also awarding the former wife most of the income-producing properties.
All right, so if so your argument is that the trial judge isn't bound by the parties' pretrial compliance.
Yes.
And what's the point of it?
I think the point is what you said, which is to narrow issues and put forth to the trial court what the parties propose be done, what they expect may be done. But in pretrial compliances in these divorce cases that are tried top to bottom, when you have alimony and child support and time sharing, we submit all kinds of proposals that...
How would you write that opinion? How would you write an opinion that gives guidance to the lawyers?
In this particular case?
With these types of issues? How do you write that? What do you say?
I think you say that absent a clear and direct stipulation or agreement, I think it's what the case law says, that you're held to stipulations and agreement that are clearly stipulations and agreement. Even now, the new...
What does the court's order say that orders the pretrial compliant, that orders the filing of a pretrial statement? What's that say?
I don't know that I can give you the verbatim because I didn't put that in my notebook, but basically what it tells us to do is to submit proposed equitable distribution schedules.
Was this an actual statement in which the former husband said, I agree the wife should have the home, or is it just in the proposed worksheet that they filed?
So all the actual pretrial statement says is there's a blurb, and it's paragraph 10 in the pretrial statement that says the parties have multiple parcels of real property which are set forth on their equitable distribution schedules. And then both parties submitted separate schedules, which they then both amended multiple times between when the initial pretrial statement was filed and when the trial actually took place, because it was continued for a while at some point due to the unavailability of a witness. So the actual statement has no delineation of all of the assets. They each submitted separate proposals, which were substantially different all over the place.
And did the trial court follow any particular proposal verbatim?
No, ma'am. He took all of the proposals and created his own, and then on rehearing, corrected some of the things that, on both sides, that the parties raised as what they perceived as some typographical, some substantive issues with the final judgment.
Let me ask you about the valuation of the Taurus Circle
Yes,
property. Sir. The wife has her expert testifying that it's valued at 30-something thousand, and,
Yes, sir.
and your client, based on Zillow, has it at twice that. The judge discounted her expert's testimony because he didn't take into consideration that the property received $800 a month in rent. Is that accurate?
Partially accurate. So, as I stated earlier, when the parties initially filed the proposed equitable distribution worksheets, they both valued it at the $70,000 number. The former husband actually testified that it wasn't not just on Zillow. Zillow was discussed in that part of the transcript, but he said, based on the other properties around it and his familiarity with it,
okay,
that's what he believed it was worth. And then the expert testified it was worth $37,000. It wasn't just because he didn't know what it was rented for. He also...
Let me ask you about that, because what it was rented for assumes that there was rental income.
Yes, sir.
Where was there testimony anywhere in this record that the property actually received $800 a month?
The former husband's testimony, while not as articulate as it could have been, was not just that, it's on my cash flow worksheet. The first thing he said was, that the former wife receives the rent. She's the one that receives it. And then he was asked...
I don't know what the rent is because she would get it.
Right, and then the questions that followed, he's asked to look to the documents they prepared, and that's where he says, it's $800. It didn't go
But
further.
what the court found is that worksheet that he relied on, that cash flow worksheet that listed $800, simply showed if the property was rented, what it could receive. That's nothing. I mean, there was never any testimony that the property actually received $800 a month. The cash flow worksheet says if rented, it should receive $800 a month, right?
Yes, that's what the trial court found, that's what the cash flow worksheet, I think, represented, but the other,
There was no $800 a month that the property was actually receiving. As your brief said a couple times, I think as you just said today, there was no testimony that there was a tenant in there paying $800 a month.
That's correct. So what the trial court did is when, and this I think goes into the alimony issue as well, in determining how much rental income the former wife would receive under this judgment, is applied a discount rate similar.
20%, where did that come from?
I think there was, the former husband testified to some of it. Lewis Hunter also alluded to some, what would need to happen for the properties to be fully rented. And again,
Any evidence in the record to establish a 20% reduction in the rental values?
nobody came out and said 20%, but as with other issues, what the trial court did and what I think is permitted within the discretion afforded to him was look at all of the evidence, look at what Mr. Hunter testified to, Mr. Dees testified to, the former husband and the former wife, because they both presented cash flow worksheets of, I don't think they were both titled that, but both summaries of the rental income that was available, through these properties.
Now, on that one property, wasn't Dietz also unfamiliar with the fact that there was a trailer on it?
Yes, sir. And there was testimony about, it was actually the former wife that had moved one trailer onto the property, and there was some, realignment of trailers, and it was newer, and she hadn't told anybody, and I think her testimony.
Right, so Dietz is valuing it as a vacant piece of property as opposed to a piece of property with a residence on it.
I actually think what he did, just to be totally clear, is he was valuing it with a really run-down and almost unlivable trailer when it was actually, I think they referred to it as a double-wide or a bigger trailer that was much newer at the time. And so that was the other reason the trial judge discounted what Mr. Dees presented. And also, an overarching issue that the trial judge raised multiple times was just the general credibility of the witnesses. He found the husband's presentation to be more credible. He found the wife was not completely forthcoming on certain issues. And so I think in those close calls, the credibility did come into play. And I think that's also permissible. Just to hit on a couple of points that was raised by Mr. Gressley. On the South End Ventures, the venture with the former wife's mother, it was clear at trial, and what the trial court found was the operating agreement of the LLC was never signed. And I think that's why the trial court reached the conclusion that it was a loan. And it was also undisputed at trial that the entity at that point in time didn't actually own anything. It was used as kind of a vessel to give and receive rents. And by distributing that particular...
Well, how was title to the properties held?
Well, so there were no properties owned by South End Ventures, LLC. The LLC was set up to kind of funnel this money that the former wife's father was loaning them to invest in these various properties, but the properties were never actually titled in the name of the LLC.
Held title to the properties was my question.
I'm sorry.
Who held title to the properties?
So the various properties were titled jointly by the parties, or, there were like 11 LLCs other than South End that owned various properties, and so they were kind of spread throughout those other LLCs. But the former wife's father in no way held title to any of those properties, either directly or indirectly at any time.
Even through an LLC?
Correct. Now, I will say that part of the evidence at trial were the K-1s through the various years of the LLC, and it did show a change in ownership. If you look at the K-1s, at one point the parties owned 90%, at one point it was 30%, but there was never an operating agreement or any kind of deed giving the former wife's father title to any property directly or indirectly. And effectively, by distributing that debt to her, what the trial court did was enrich her by that much, and if it's not really a loan that she will have to pay back, it's really a benefit to her because she's getting assets.
Yeah, there were loans from his family that he
Correct.
might not have to pay back.
Correct.
But we don't know that.
I'm sorry.
We don't know that. We don't know
Right.
We
don't know, but I think it's clear on that point and many others. The trial court here after 4 or 5 days of evidence that was probably sometimes a little unclear and complicated and overlapping, did a really good job of trying to reach a fair and equitable resolution, an equitable distribution where the former wife was paid an equalizing payment. On the alimony issue, he did exactly what you're supposed to do when incomes are in flux and preserved her right to permanent alimony with the nominal alimony award. And just to end where we began, the finality of this judgment I don't think can reasonably be questioned. I think, again, it's also not preserved for appeal. We think the trial court did hear what trial courts are supposed to do in family law cases, and we'd respectfully ask that you affirm the judgment.
Thank you.
Thank you, Your Honors. 1, jurisdiction cannot be conferred by waiver or agreement of the parties. That's the answer to the first question. If this thing is not final, which I submit is the case, it doesn't matter that it was never raised. As for the Sheffield property, I know Ms. Sussman, and she would not misrepresent something to you, and my memory is my memory, which is shaky. But I thought that there was testimony from both parties that they had agreed that Sheffield would be to my client. Importantly, the motion for rehearing, my client's motion for rehearing, page 5, footnote 12, list out in excruciating detail every single proposed equitable distribution sheet where both parties agreed that Sheffield would go to my client. Page 4 of the initial brief, I list those record sites. It is clearly in the record.
You are out of time, sir.
Gosh, and I was having so much fun. Thank you very much. And thank you for the good story about the bass boat and the fishing.